Great news, actually, out of Maryland. We had, this is outrageous in actually a few ways, though, but was a good result in the end. We had a court case in Maryland because, as you may know, we have this election integrity project going on, and it's been going on for several years now, where we're trying to get the law requiring states to take reasonable steps to clean up their rolls enforced. And we filed the first private lawsuits ever in history to get that rule enforced, both in Indiana and Ohio. And the Supreme Court upheld our settlement in Ohio to require them to take steps to clean up the rolls. They upheld that settlement last year. And that led to the settlement that I've talked about before with LA County in California that has begun a process in California to remove up to 1.59 million inactive voters. And in Kentucky, we have a consent judgment. They've begun a process to remove up to 250,000 inactive voters. We expect them to probably pursue another 250,000 after that. But there are many, many states, too many states, where they have counties that they have more people on the rolls than are eligible to vote. If you have a county with more people on the rolls than are eligible to vote, that's a pretty good indication you're not taking the necessary steps to clean up your rolls. And in Maryland, Montgomery County, which is the state's largest county, sanctuary county as well, by the way. So if you look at the map, you've got the District of Columbia here, and then Montgomery County is right above it. So it's, a lot of people who live and work in the district, live in Montgomery County. I forget the population, but well over 1 million people, so it's a big county. They have a 105% registration rate. What does that mean? It means everyone who lives there is registered who's eligible to vote, which obviously ain't right, because that number is never achieved by any normal county that keeps up with its rolls. Plus 5%. So they got more people on the rolls than are living there and eligible to vote. So we filed records requests under this law I told you about, asking for more voter data about it. Well, you wouldn't believe the response we got from Maryland. They went on some anti-Trump tirade against us, told us we couldn't ask the questions, that only Maryland voters could get the records. It didn't matter what federal law said about requiring you present these records. And believe it or not, they demanded from Judicial Watch and Discovery information about whether we were Russian agents. We told them to go jump in a lake with that outrageous smear, defamatory smear. But that shows you how radical and outrageous some of these, and these were left-wing politicians in Maryland, by the way, are in defending their lawlessness. This was a basic request. We settled a lawsuit with LA County and the state of California, no friends of conservatives, because they understood, to their credit, what the law requires. It ought not to be a partisan or ideological issue. But they made it into one in Maryland. And thank God a federal court judge saw through this and ordered the state of Maryland to produce voter list data for Montgomery County to Judicial Watch, so we can try to figure out what's going on with the dirty lists there. I'll quote from the ruling. If Judicial Watch had submitted requests for voter registration data corresponding to the thousands of Montgomery County voters, the state would have been required to produce each record pursuant to Section 8I, which is the section of the law, federal law, that requires them to turn over information to us. Instead, Judicial Watch merely submitted a single request for a voter list containing and compiling the same information about the thousands of voters in Montgomery County. Although both scenarios seek the same information, defendants, the state of Maryland, believes that the NVRA, the National Voter Registration Act, would require compliance with only one of them. Rejecting Judicial Watch's request based on semantics would be tantamount to requiring Judicial Watch to make thousands of separate requests. Neither the NVRA, the court, nor common sense can abide such a purposeless obstruction. You heard it. That's how they described the politicians we were fighting. That's how the court described them. Engaging in purposeless obstruction. Organizations such as Judicial Watch have the resources and expertise that few individuals can marshal. Thanks to your support. By excluding these organizations from access to voter registration lists, the state law undermines Section 8's efficacy. Accordingly, the Maryland election law is an obstacle to the accomplishment of the NVRA's purposes, which is to make sure that there are reasonable steps being taken by the states to clean up the rolls. It follows that the state is preempted so far as it allows only Maryland registered voters to access voter registration lists. So this is a great victory. But isn't it outrageous that we had to go through that fight? You could see what the court was saying there. You had taxpayer money being wasted on purposeless obstruction on this basic request for information that Judicial Watch was making in the public interest to make sure that the voter lists in Montgomery County, Maryland, and the state of Maryland were being cleaned according to federal law. So I'm hopeful now that we've gotten this positive court ruling that we can now begin to proceed with our efforts to require the state to clean up the rolls. And who knows, maybe they'll settle with us like we did in Los Angeles County in Maryland and in California. Maybe their anti-Trump fever is past.